Court of Appeals for the Fourth Circuit. Oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to draw nigh and give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, please be seated. All right, we're prepared to hear argument in Jallo v. Garland. Is it Ms. Corbett?
Honor. May I begin? Thank you. May it please the court, my name is Zinzibar Corbett, and I appear on behalf of the petitioner in this case, Mr. Osman Jallo. We are asking the court today to grant Mr. Jallo's petition for review for the following reasons. Mr. Jallo is a local permanent resident and he has held this status since March 12, 1996. He is not an alien who is seeking a waiver and is required to establish hardship to remain in the United States. As an alien charged as removable under Section 8 U.S.C. 1227, the standard is different than someone who is applying for their LPR status for the first time. He was placed in proceedings because of 4 convictions that were for possession of marijuana or possession of drug paraphernalia relating to marijuana.
Well, how does the record tell us that that drug paraphernalia was adjunct to marijuana? Where in the record can we find that?
I seek an audience, Your Honor. We can rely on the petitioner's own credible testimony, and I will refer to the admin record specifically. I seek your indulgence.
Well, the reason I asked that, I assume that the BIA rested their decision that either they didn't believe your client or that there's just nothing but an assumption that marijuana was involved.
Well, we can rely on the petitioner's own credible testimony at his individual hearing, and this was at the admin record page 435, specifically lines 4, and also lines 14 to 15, where he did state in his own testimony that the convictions he had were relating only to marijuana and nothing else. And also the police records in the evidence in the record also state that the charges he had and the convictions were all relating to marijuana.
What we have before us is your motion to reopen, correct?
Yes, Your Honor.
What I wanted, just a preliminary question. Hasn't it been 9 years since the final administrative ruling?
It has been, Your Honor.
That's pretty untimely to make a motion to reopen 9 years after a final administrative decision. It's supposed to be filed within 90 days.
Yes, sir, and we do concede that fact. And I would state at this time, I need to seek post-conviction relief for Mr. Jallo and the successful vacatur of 3 of his convictions and also his lifelong medical condition that did render him disabled up until this day. I believe those were factors that did constitute and lead to the delay in filing of his new motion to reopen. But there were sufficient circumstances to establish a prima facie case of eligibility and also to equitably toll the filing deadline in his motion to reopen case.
If we excuse that, what are we saying about timeliness and administrative removal proceedings?
Your Honor, I do think that facts in this case are very specific, given his medical conditions and his criminal history, that he did need to seek post-conviction relief for these 3 or 4 convictions. And I do think that it is to stretch the law to grant it in this case, because he did have 4 convictions that did initially render him ineligible. But once he was able to seek successful post-conviction relief, the circumstances in his case did change, and he did at that time warrant a reopening of his case.
Let me ask you this: both sides seem to be, I don't know, maybe just oversight, inconsistent in the use of the terms permanent resident or non-permanent resident, and also as to which statute would apply. What is he? Permanent resident or non-permanent resident?
Your Honor, in this case, Mr. Jallo is a lawful permanent resident.
And the section that you are asking for relief under is 245.
Well, he was charged as removable under 8 U.S.C. 1227 as a deportable alien.
Okay.
And it's also under that section where he qualifies for the relief under 8 U.S.C. 1227 A2B1.
And the ground for the BIA's decision here was just on a paraphernalia ruling, right? They assumed that equitable tolling would apply and said, assuming all that, he doesn't qualify because paraphernalia doesn't qualify, right?
That is correct.
Regardless of the amount of marijuana or this, that, or the other.
That is correct. That was the ruling in their decision of his case.
And you argue that that is not consistent with their precedent.
We do, Your Honor. And if I may, can I cite the 2 BIA decisions that were issued that are very specific to this case? The first was Martinez-Espinoza. And in that case, the board held that an alien who is inadmissible based on drug paraphernalia offense may qualify for a waiver of inadmissibility under Section 212H of the Act if that offense relates to a single offense of simple possession of marijuana, 30 grams or less. In this case, it was held that trace amounts of marijuana on paraphernalia will still permit a respondent to qualify for protection under the code 8-1227 A2BI if he was charged with possession of drug paraphernalia, and in this case, Mr. Jallo was. And given that trace amounts of marijuana on the paraphernalia were what were found by the police, and that led to his charge and subsequent conviction, it is our position that he qualifies for the exception under 8-1227 A2BI based on Martinez-Espinoza.
The BIA argues that you've already conceded that your April 2000 paraphernalia conviction made him removable, and that concession is binding. What do you have to say about that?
Your Honor, as the facts were, when Mr. Jallo pled his NTA in 2009, he had 4 charges before him, and he pled to all 4 charges based on the facts as they were at that time. But facts did change subsequent to his pleading to the NTA. That led to the successful, my apologies, post-conviction relief and vacatur of 3 of those convictions, and then the circumstances changed that warranted the reopening of his case. Mr. Jallo should not be bound to his pleadings because the law also permits parameters by which a respondent may seek the opening of his case. And in this case, it is our position that the petitioner did in fact meet the standard, and he didn't in fact merit reopening of his motion to reopen before the court.
The board's decision was factual in nature, was it not?
Yes, Your Honor.
Don't we owe some deference to those determinations?
Yes, Your Honor, you certainly do. But I would just put forward once again that the circumstances after his pleading to the NTA in 2009, they did in fact change. And it is for that reason that he filed a motion to reopen in 2010, seeking that the courts actually open his case once again before the court.
You're pleading an exception here because normally individuals convicted of drug offenses are thought to be removable, and when you're pleading an exception, you bear the burden of establishing the exception. And BIA argues that you introduced no evidence that the paraphernalia here was related simply to a small amount of marijuana possession. what reason do we have to say that you've played the exception?
My apologies, Your Honor. In response, I would note that we can rely on the petitioner's own credible testimony at his hearing. And I would refer the court once again to page 436 of the record, lines 4 and also lines 14 to 15, where he did state that his convictions were related to marijuana. And also the police record in this case does state that the convictions were relating to marijuana. Unfortunately, we cannot obtain a copy of the chemist's.
So weren't you stating, when in your response to me, weren't you just stating a conclusion?
No, Your Honor, I was actually referring to portions of the record where the police report and the testimony of the petitioner support that the convictions were relating to marijuana.
When she was arrested, or he was arrested, for drug paraphernalia, weren't there other charges that were brought?
My apologies, Your Honor. Yes, there were other charges.
What were those other charges?
I seek indulgence, Your Honor, to refer to the record. I humbly seek your indulgence. The other charges include a charge for theft that was also levied against Mr. Jallow in that case, or from that incident. And I do believe there was at least one other charge that he was charged with on that day.
Excuse me, I didn't hear you.
I said he was charged with theft on that day also, Your Honor, and I believe there was at least one other charge, and I'm currently searching for my notes. I seek your indulgence.
I thought there were several other charges that were brought in connection with the arrest for drug paraphernalia.
Yes, Your Honor, there were.
Why couldn't, maybe that's not by itself dispositive, but it certainly could be used as evidence by the BIA or any administrative tribunal that the possession of marijuana was not, or paraphernalia was not purely a personal thing, that there were distributional activities or more serious activities involved. And given that, in addition to the fact that there's, so I just see there are a number of problems here. There's no evidence. And it's important when an exception to a statute is like this is passed, that one bear one's burden of establishing the exception. And it seems hard in this sort of vacuum to overturn the BIA, and the additional problems present themselves of the concession that you are removable, your client is removable, and this thing comes to us 9 years after a final administrative decision that's supposed to be challenged within 90 days. I realize you've cited various extenuating circumstances, but there seems to be, they do seem to be multiple problems here. And not just one, but there seem to be an evidentiary absence and vacuum, and in addition to the substantive problem of proof, there are the process problems of untimeliness and an earlier concession of removability. So we're trying to deal with both an absence of evidence and all of the procedural difficulties as well. There's several things. You see the problem?
I do, Your Honor. And if I may, as to the procedural deficiencies, we do want to also emphasize the fact that Mr. Jallow does suffer from a lifelong medical condition, namely osteomyelitis, and this really did cause him this delay in filing his motion before the board, along with the need to seek post-conviction relief. I do believe that these factors cumulatively did constitute or lead to that 9-year delay, which generally is unfavored by the board and by the courts. But in this case, there were specific facts that led to the delay in this case.
All right. Thank you very much. If my co-panelists have no further questions, I'll ask the attorney for the government to come forward.
Thank you.
Good morning, and may it please the court. My name is Stephanie Groff, and I represent the Attorney General. Your Honors, at first, I want to clarify something very important. Mr. Jalla is no longer a legal permanent resident, and this is because the board last issued a decision in this case in 2010, and in that decision, it upheld the immigration judge's finding that he was removable for convictions related to drugs, and this is under 8 U.S.C. 1227 A2 EI. Mr. Jalla's claim today that he is still a legal permanent resident is unfounded and not supported by this record. Moving on to the important aspects that Judge Wilkinson mentioned in his questioning, this board should uphold the board's denial of Mr. Jalla's untimely motion to reopen because Mr. Jalla failed to demonstrate that he is prima facie eligible for what he seeks, which is reopening and termination of his proceedings, as his concession of removability before the immigration judge is binding and cannot be disavowed years later in an attempt to seek a more favorable result. And even assuming that this concession is not binding, the record is devoid of any evidence that his conviction for drug paraphernalia would fall under the personal use exception related to marijuana.
Let me ask you one question here. A lot of these cases come up to us in which the board argues that its denial of the motion to reopen was not an abuse of discretion, and we have that aspect of it here. And then the board, the BIA also sort of tacks on a jurisdiction. And oh, by the way, and a lot of times this is at the end of a brief, oh, by the way, you don't have jurisdiction to review this either. Now, which is the board seeking here, a jurisdictional dismissal or the fact that there was no abuse of discretion in denying the motion to reopen? And as I see it, the jurisdictional provision is addressed specifically to final orders of removal. And is there a final order of removal here that would deprive us of jurisdiction over what does seem to be a factual matter and not a matter of statutory law or constitutional law? It's just a question of how a particular exception applies to the particular facts of the case. So how does your merits argument dovetail with the jurisdictional provision? Is there a final order of removal here that we must grant a jurisdictional dismissal, or are you arguing strictly on the merits of the denial of the motion to reopen? What are you asking?
Yes, Your Honor. The government acknowledges that sometimes these issues can be conflated, especially here when there are claims related to the board's abuse of discretion. It does kind of confuse the issue. However, here, the final order of removal was upheld by this court actually previously back in either 2010 or 2011. Before the court today, This court is looking at whether the board abused its discretion in the motion to reopen. And that is the questions related to concession of his charges and whether the board abused its discretion. But assuming that the board didn't, and in all the alternative in our brief, we did argue that Mr. Jala is a criminal alien based on his concession that he is removable for 1227 A2ABI, and therefore as a removable non-citizen, this court would be barred unless there is a constitutional or legal question.
All right, so we do have a final order of removal here. You're arguing.
There is a final order of removal. However, this court's already reviewed whether that final removal was valid based on the board's upholding of it back in 2010 or 11. What we have before you today is the board's denial of the motion to reopen. And the government
can we review that? You put it that a lot of times these briefs conflate these things, and I try to figure out how to do it, and it seems to me that what you're really asking is the sort of a dual ruling, that there was no abuse of discretion in declining to reopen, and to the extent that you're asking us to review a final order of removal, the matter is purely factual and we're without jurisdiction to do that. I mean, I think you're sort of two things are involved, and you argue that you win on either one.
Well, Your Honor, you said it perfectly. Yes, this is the first issue that this court can look at, is whether the board did abuse its discretion. And this court does have jurisdiction to do that. Again, this is a difficult burden to meet, as the board does have discretion to decide whether or not to open a case, especially here when it is.
How is this a factual ruling? My reading of the BIA's decision was they didn't assess the evidence. They said, even assuming that his offense involved 30 grams or less, he doesn't qualify because this was a paraphernalia offense. That's not a factual determination, is it? Isn't that a legal determination that this is what this means? This requirement means that any paraphernalia offense doesn't qualify?
Well, Your Honor, first I would point this court to the board's first addressing of Mr. Jala's concession of removability back before the immigration judge.
What about what I just asked?
Well, what you just asked, yes, the government does concede that the board did make an error in this case when it stated that drug paraphernalia would not constitute for the personal use exception. That is a legal error. However, the government here would argue that this is harmless error and there's no need to remand it back to the board. And that's because even looking at the evidence that we have.
So you're saying you concede that the board made a legal error, but then you ask us to move on and assess the facts for ourselves in the first instance without a board decision assessing the facts. You ask us to undertake that factual finding without sending it back to the board, because you say we can do that because the evidence shows that he wouldn't be entitled to it anyway.
Well, the government is asking first that this board look to the board's determination relating to the concession, and that determined that Mr. Jala did not establish that he's prima facie eligible for reopening. Then in the alternative, even assuming that this concession is no longer valid, that is when the board did make its error in determining that drug paraphernalia cannot constitute for the personal use exception. We argue that this is harmless error because the board relied on first that concession. That is a factual issue. Whether
the concession, I mean, is it a factual issue? The question is, can someone be held to something? Isn't that the whole purpose of a motion to reopen, I guess, is that if the facts change, you can come back and say, you know, the facts were one thing when the board originally made its decision, but the facts have changed and I'm coming back and asking you to reopen. And wasn't his concession based on different facts, that he had these 4 convictions and now he doesn't? He only has one that doesn't qualify. So, I mean, what's your authority or the sort of legal proposition that he can't change his concession when the facts undergirding that concession have changed?
Yes, Your Honor, and respectfully, the record here still does establish that he has this drug paraphernalia conviction for marijuana, which was presented back in his notice to appear back in 2010. The government also would point to various decisions by this court, some unpublished and some published, relating to the concept of concession. It is in the regulations. It states that an immigration judge can rely on concession as long as that immigration judge sees that there's no issue of law or fact. And a concession can be made either by a non-citizen or their attorney. As long as the immigration judge is satisfied, they can rely on this to determine that the government has met its burden of proof. And that is the situation we have here.
Well, no one's disputing that the agency could rely on the concession 10 years ago, or whenever this this decision originally came out. The question is now that the facts have changed and his concession is no longer true, right? He no longer has these convictions because he sought post-conviction relief and got them removed. And now his concession is just, it's not true anymore. And I didn't see much of anything to go on in the law as to whether a petitioner can't come back to the board and say, I want to reopen. Facts have changed and my concession is no longer substantiated in the facts.
Well, first I'll point this court to this court's decision in Salem v. Holder. This is a Fourth Circuit decision which discusses a non-citizen's concession of removability and the properness of an immigration judge relying on it. Additionally, in an unpublished decision in Asiano v. Garland, this court mentioned that it's a well-settled principle that once a non-citizen concedes removability, it's not something that can be years later gone back and addressed and changed. And here the situation is not necessarily different. The government does not concede that the three convictions that Mr. Jalla alleged are no longer proper were dismissed for procedural due process. That has never been addressed by the board. It could be possible that they were done for rehabilitative relief, which would still qualify a conviction for immigration purposes.
But again, that's not the board's reasoning. And all our job is on review is to look at what the board said and make a decision based on that. Now the board, if this gets remanded, the board might look and say, we can't accept his concession because we don't agree that these 4 convictions aren't still valid and aren't still out there. But that's not what they said. They said, you can never take it back, even if the facts have changed.
Yes, Your Honor. I would also point this forward to other circuits that have addressed this issue, which is a non-citizen years later attempting to challenge his concession. For instance, the Second Circuit in Huda v. Holder discussed this exact issue. It stated that a non-citizen cannot years later attempt to challenge a previous concession without any evidence that this concession was, say, made by ineffective counsel or with questionable circumstances. And the Second Circuit in that case said that looking in hindsight, yes, it might have been better if the non-citizen didn't concede, but that's not the case and it can still be relied upon.
I appreciate you giving me case law because this is not an area where there's a lot out there, but it strikes me as this is still different, right? Where it's not looking backward and saying, oh, that was an unwise concession and I've changed my mind. I wish I hadn't done that, but rather it was appropriate at the time because the facts supported it, but now the facts have changed.
So, Your Honor, the government respectfully disagrees because Mr. Jalla's conviction for drug paraphernalia, which was in his NTA at the time that he made his concession, is still valid. This is the 2000 conviction for drug paraphernalia. If there was this, if any of the evidence supported Mr. Jalla's argument today that this was for personal use and that it was for a small amount of marijuana, this concession back in 2010 was made in error and should not. It does not matter if it's all 4. Under this removability statute are you removable for a crime related to a controlled substance? The 4 of them didn't matter, whether there's 1, 2, 3, 4. And the last one, the 2000 drug paraphernalia, the government is arguing is still valid. That concession establishes that he is still removable.
And that's a good point, right? So that he had 4. He didn't have any argument that he wasn't removable for a drug crime because there were 4 drug crimes. But you're saying he should have said, well, the paraphernalia one doesn't count, even though I concede I am removable for these other 3.
Absolutely, Your Honor, and he could have done that. The problem here is that the record is devoid of any evidence to show that this drug paraphernalia conviction would fall under the personal use exception. While opposing counsel did mention that some records are no longer valid,
I mean, even at counsel, even at this late date, when you read, there's simply no evidence brought forth that this was simply for personal use. If there had been, well, we might have a different case, but there's just no evidence that this marijuana was simply for personal use, even after all this time. And the other question I have is, after 9 years, things are always going to change. There's always, I mean, that's a long period of time, and we would essentially be throwing open the gates to motions to reopen after on the basis of changed facts, when the facts, whatever facts that are changed, don't go to the evidence.
Absolutely, Your Honor. And that's why this court has repeatedly held, the board and the Supreme Court, that motions to reopen are disfavored because any delay works to the advantage of the non-citizen. While the government does acknowledge that Mr. Jalla does suffer from a disability, that does not change the fact that he established that even assuming timeliness that the board found, even assuming that he merited equitable tolling, he has failed to demonstrate that he is prima facie eligible for reopening and termination, and this court should uphold that for abuse of discretion.
Well,
To Judge Rushing's point that she's been trying to make with you, I think what she said is they just didn't do the analysis in the first instance. So why don't you send it back and let them do the analysis and come back and case closed?
Sorry, Your Honor, just to clarify, are you stating the analysis relating to timeliness and equitable tolling, or
No,
related to
the adjunct?
the crime?
Yeah.
The crime. Yes, so this, the government would argue that the board's analysis related to whether or not Mr. Jalla conceded his removability, and if he's challenged that on appeal to the board, or that he's mentioned it in his motion to reopen, that he didn't meet his burden, we would argue that this court can properly uphold that finding. And then again, even assuming, acknowledging that the board did make a mistake here as it relates to drug paraphernalia, because it has repeatedly held that it could constitute could constitute personal use exception, we would argue that, again, this is harmless error because sending it back shows that there is still nothing in the record. Again, every delay works to the advantage. This case was decided in 2010. When they filed the motion to reopen, it was 9 years later. And still before the board and this court, there's nothing to show that it related to personal use. Judge Wilkinson asked opposing counsel about other charges when he was arrested for drug paraphernalia. The government would point to the fact that he was arrested for theft, unlawful taking of a motor vehicle, possession of marijuana, a false statement to a police officer, and drug paraphernalia. In the record, or in the evidence that Mr. Jalla submitted in his motion to reopen, all it states is that this drug paraphernalia is still a guilty plea. And this government would note that the former charge of drug paraphernalia, which he was charged under, 237, is no longer applicable in Maryland. In fact, it's now under a different charge, 619 of Maryland Code. And it's important to note that now that charge for drug paraphernalia states that it does not apply to personal use of marijuana. And again,
well, Counselor, it is a very, very rare thing that we grant motions to reopen, and particularly after this length of time, and numerous courts have explained why that is so. And if we started granting these motions to reopen, we've moved the process into a point of interminability, and it would just open the gates to an avalanche of claims, and it would be eroding the definition of any definition of finality in these immigration proceedings, which the Supreme Court in the Niken case has taken steps to indicate that finality in immigration matters of immigration law is an important consideration, and reopening a case like this, at least if you're going to reopen, you would want to have a more compelling set of circumstances than you would find here. There's still a total absence of evidence that this reopening is warranted.
Yes, Your Honor, the government would agree with your assessment. Again, while the government acknowledges that Mr. Jala does suffer from osteomyelitis, he has had this condition since he's been in the United States, and the immigration judge and board in its initial determination acknowledged this and noted, and Mr. Jala himself testified that years down the road, he may need further surgery. In his motion to reopen, he mentions that he's recently had further surgery, another reason to reopen. But again, this is not the case that he has met. May I briefly conclude?
All right. If my colleagues have questions, I'll ask that you entertain those. Judge Rushing, do you have further questions?
No, thank you, Judge Wilkinson.
Judge Floyd?
Thank you so much, Your Honors.
All right, let's hear from counsel in rebuttal.
Thank you, Your Honor. Please allow me to correct the record. Mr. Jala was in fact a lawful permanent resident, but now he is not because he was ordered removed, as my opposing counsel correctly stated, and we are now trying to get back his LPR status in these proceedings. I would like to focus on the fact, Your Honor, that the BIA actually never addressed the issue of whether he actually gave enough evidence for his motion to reopen. And this is not harmless error as was put forward by my opposing counsel. Given that the board never actually considered this issue, we do believe that this merits a remand to the board so that they can properly consider this issue before them. This court in Oyemi versus in immigration naturalization has stated 3 independent grounds on which the board may reopen a case. One of these is where the respondent has, I seek indulgence, where the alien has not established a prima facie case for the underlying relief sought, underlying substantive relief sought. In this case, Mr. Jalo has presented enough evidence to establish reopening of his case, and the board did not consider this evidence before them. Instead, the board went right to the merits of the case and proceeded to establish that his conviction did not classify, his conviction for paraphernalia was not sufficient for him to merit the exception under 8-1227 A2BI. Given that the board never considered this issue, this case should be remanded on that case alone, on that issue alone. My apologies. Secondly, Your Honor.
Can I ask you a kind of factual procedural question? When a petitioner conceded removability because he had a drug conviction, is that just a general concession, or does that go conviction by conviction and say, you know, for conviction number 1, I'm removable because that's a drug crime. For number 2, same. Number 3, same. Or is it just a general agreement with the government that, yes, I have 1 or more convictions for a drug crime, and so I'm removable?
Thank you, Your Honor. And based on my review of the record, it seems to have been a general admission to the charges before him, because if you look at the NTA that is part of the record at page 14 at line 6, there was no mark that he actually admitted the allegation for the April 17, 2000 conviction. Based on that fact, it does seem that his admission to the facts as they were at the time in 2009 was a general admission, as opposed to an admission to each conviction in the notice to appear.
So it's an admission that at least a conviction exists, but it's not necessarily an admission to the underlying facts.
That is correct, right? And I believe that had the facts been different in this day and age, had he been in immigration court today with a single conviction for drug paraphernalia, he would have pled differently because circumstances have changed than they were in 2009. Thanks. Your Honor, I will continue to put forward that the board's lack of a decision on the issue of his motion to reopen and whether he in fact established a prima facie case was not harmless error. The board was required pursuant to Onyembi versus U.S. Immigration Naturalization to actually rule on this issue, and they did not for whatever reason, we do not know. And it is not within this board's jurisdiction now to deny his petition for review because the board did not address that issue. It was the board's jurisdiction and responsibility to properly address this issue when this case was before them, and they failed to do so. Had we been in immigration court right now, I do believe that Ms. Giles pleading to the NT would have been different. It is fundamentally unfair now to say that he is stuck with this concession, because he would have pled differently had there only been the April 17, 2000 conviction, for which he would also have been eligible for an exception pursuant to 8-1227 A2 BI. And I refer to the court to the matter of Davy, where the board held that an alien may be covered by the exception if the alien's crimes were closely related to or connected with a single incident in which the alien possessed 30 grams or less of marijuana for his or her own use. And the facts in this case also support the fact that this case is squared in line with matter of Davy, and the board did not rule on this issue. For this reason, this case should be remanded so the board can properly consider this issue in line with their own presidential decisions in matter of Martinez Espinoza and matter of Davy. Thank you, Your Honor.
Thank you. We appreciate your argument. We will, sorry we can't shake your hands, but I think you understand why that is so. We appreciate your argument nonetheless. United States v. McClammy.
Thank you, Your Honor. May it please the court. I am Assistant Federal Public Defender Laura Koenig with the Eastern District of Virginia, and I represent Carlos McClammy, appellant in this case. There are two primary issues in this case. First, the district court erred when it concluded that Mr. McClammy's 924C conviction in count 4 was predicated on bank robbery rather than Hobbs Act conspiracy. The criminal information, without any ambiguity, charged a single offense, namely Hobbs Act conspiracy, as that predicate. Mr. McClammy's co-defendant also got relief on the same Section 2255 motion, the same argument in 2019 on a 924C conviction that was identically worded. But even if the court finds that the predicate in count 4 was ambiguous, the court must resolve such ambiguity in favor of Mr. McClammy. And the district court incorrectly held otherwise. Second, after the Supreme Court's decision in Borden versus United States, bank robbery is no longer a crime of violence. Between the plurality decision and Justice Thomas's concurrence, Borden holds that only specific intent suffices under the force clause. Because this court in McNeil did not have the benefit of the clarification in Borden.
Oh, the bank robbery, on the Borden point, the bank robbery statute has a knowledge as its mens rea, does it not? Doesn't seem that it says recklessness. Says that knowledge is necessary. There's the necessary mens rea.
That's right.
And McNeil is emphatic on that same point.
That's correct, Your Honor. the Supreme Court in Carter, this court in Woodruff, and also McNeil have found that the bank robbery statute in 18 USC 2113A is a general intent crime, meaning that knowledge suffices. Specific intent is as Woodruff found, not even considered as an element for the bank robbery crime.
Well, isn't all that Borden did was to nullify predicates with a mens rea of recklessness?
Well, Your Honor, I think it's an interesting question because when we look at the effect of how the decisions came out in Borden, we have 4 justices that sided with Justice Kagan. We have Justice Thomas who concurred, and then we have 4 justices who dissented. And when we look at this court's analysis of the Marks rule and how we govern what is a rule from a case in which there are split decisions, in and I apologize, A.T. Massey Coal Company, this court has observed that we have to look and see if there is a implicit majority. And so when we look at the 4 justices that sided with Justice Kagan in Borden, we see that those 4 justices agreed that specific intent is at least something that must be found. And then Justice Thomas specifically finds and only finds that it is specific intent that is required. And so
where are the words reckless disregard used in the bank robbery statute?
I apologize, Your Honor, I didn't hear the court's question.
Where are the words reckless disregard used in the bank robbery statute as a satisfactory mens rea?
Your Honor, I don't believe they are.
Well, isn't that important?
It is very important, Your Honor. And so that is in part why when we're looking at what the court's precedents, what the statute requires, it has to be a higher threshold than what was found.
Well, what I'm saying is I don't understand how you can say that Borden is of assistance to you and there's nothing in the bank robbery statute that suggests a mens rea that is of some lesser order or quality than knowledge.
Well, Your Honor, when we look at the Supreme Court's decision in Carter makes clear that 2113A requires general intent, which is understood to mean knowledge. And so when we're looking at the threshold that for general intent versus specific intent requires that it be a purposeful act, that it be something that is the specific intent of the individual committing the crime.
But this is all a house of inferences, isn't it? To try to compensate for the fact that the statute itself doesn't set forth a mens rea of recklessness. I mean, I don't disparage your argument. It's very creative, but it is a house of inferences.
Your Honor, this court is bound by the Supreme Court's decision in Carter, and I appreciate the court's comments.
Well, didn't we expressly reject in McNeil that bank robbery can be committed recklessly?
You did, Your Honor. And so in McNeil only addressed that it is the general intent that is required. And our position is that after Borden, the force clause requires the court or that the use that there's evidence to support a specific intent. And that's what is missing here. But I want to make sure that
so your argument hinges on us kind of overlooking a significant portion of the Supreme Court's decision in Borden, right? There's a discussion of how specific intent is enough, how knowledge is enough. There's a discussion of how that would happen. I think there's a traffic accident hypothetical. It's pretty clear the Supreme Court was telling us that knowledge is enough. And the Marks rule doesn't seem to help you, even if we read Justice Thomas's opinion to be stricter, because that's not how the Marks rule works. So McNeil seems to still be in good standing if knowledge is still sufficient.
I appreciate the court's question. Our position is that after Borden, specific intent is required. I do want to emphasize, though, this court has no need to even foray into the bank robbery discussion, because what happened in the district court is that it is very clear that count 4 is predicated on Hobbs Act conspiracy.
But don't we,
Well,
they kind of work together because of the cause and prejudice problem, right? This was defaulted. And if we get to prejudice, then there's a question of, would the alternative predicate have been supportable? On the alternative predicate is bank robbery.
I think it's really important to parse that out very carefully, Your Honor. So when we look at cause is established when a constitutional claim is so novel that its legal basis was not reasonably available to counsel. I don't think that that question should be in dispute. Johnson clearly did away with the residual clause in 924C, in the residual clause, and Davis applied that same finding to the residual clause in 924C. When we get to the prejudice,
how could you be prejudiced because the government would simply have, if you'd raised a problem with this and had not procedurally defaulted and had raised a Davis claim or whatever, the government would have simply shifted the predicate over to one of bank robbery, and it was in your interest equally with whatever predicate there was, it was in your interest to accept the plea deal.
Your Honor, so the prejudice standard that the government is proposing is one that requires a fact-intensive search, but that's not what the law requires. Frady requires that a prejudice is found when the error works to the actual and substantial disadvantage to the claimant. And so when we're looking at Mr. McClammy's case here, first, I think it is really important to appreciate what the government did here. When someone is charged with conspiracy to commit bank robbery, that conspiracy charge can only be brought in 18 U.S.C. 371. That carries a 5-year statutory maximum. So
this wasn't just a conspiracy question with respect to the bank robbery. The conspiracy was with respect to the Hobbs Act.
True.
The bank robbery, it seemed to me, when you get down to the question of the predicate for count 4, the specific references to overt act 6 of count 1, which is quite specific and not general, but it charges a specific bank robbery on a specific day.
Well, Your Honor, Your Honor.
Go ahead.
Your Honor, neither count 1, which is the Hobbs Act conspiracy count, nor count 4 identify any basis in the statutory language of 2113A. Both counts 1 and count 4 identify the basis, the predicate, as 1951, which is the Hobbs Act statute. 2113A does not contain a provision that the bank robbery can be committed by conspiracy. So therefore, in order to charge that there is a series of bank robberies that are involved in a conspiracy, the government has to charge it as a Hobbs Act conspiracy. And in so doing, they increase the statutory maximum to 20 years. They also, by charging it as a conspiracy, get to lump in other robberies that are considered for relevant conduct purposes for the guidelines. And they also increase the loss amount under the guidelines section 2B 3.1. So there's a very strategic reason for the government to have charged this as a conspiracy. And so it's not just a matter of happenstance or a scrivener's error that it happened to say 1951 as opposed to 2113A.
Well, if this had been a trial instead of a plea, wouldn't the government have had to prove a bank robbery occurred?
Your Honor, what the government would have had to have proved as charged in the count 4 is that there was an agreement to commit a Hobbs Act robbery, and that agreement was committed in furtherance of, or that the gun was discharged in furtherance of that agreement. That is what the government would have had to have proved at trial as it relates to count 4. So when we're looking at prejudice.
But you're conceding the point that you don't need a separate charge in conviction on a 924C predicate. You
Absolutely.
just don't need that.
That's
It's enough that a reasonable jury could convict on that, and I don't understand why a reasonable jury wouldn't be able to convict on that in view of the fact that there was a guilty plea With count 4 of the information is so specific
So-
as to the time and place and circumstances of the bank robbery. I haven't seen anything to persuade me that a reasonable jury would fail to convict on a bank robbery charge. And in fact, there wasn't anything in the plea colloquy or anywhere else that would raise that point or suggest it.
Well, Your Honor, we have several important things. One is the information itself. 2 is the prior district court order that denied Mr. McClammy's motion to amend his 2255 originally in 2018 that described count 4 as being based on Hobbs Act conspiracy. We also have the evidence that Mr. McClammy's co-defendant received a 2255 and an identically worded relief under 2255 on an identically
All right,
worded.
but let me assess. I thought there were stipulated facts, both at the time of the plea colloquy and in the plea agreement.
There are, Your Honor. There are
What?
There are stipulated facts, Your Honor.
There are stipulated facts, and I thought that the stipulated facts were the 924C offense in count 4, all pointed to the bank robbery as an adequate precedent.
Right, and this is where the distinction between the standard for prejudice and the standard for actual innocence is very important. The actual innocence standard requires this court to look at the underlying facts. The actual innocence as it relates to count 4 only applies if this court finds that the bank robbery or that the 924C count.
How can we find actual innocence in light of the stipulated facts and in light of the guilty plea?
So, Your Honor, the only way to find actual innocence in count 4 is one of 2 ways. One of which is the court finds, as I think it should, that the count 4 is predicated on Hobbs Act conspiracy. Because when we look at the facts, what Boosley tells us to do is when we look at the facts, we look at the count that is charged, unless there is evidence in the record, which is not present here, that the parties negotiated away a more serious charge. So when we look at the count that is charged here, which is Hobbs Act conspiracy, it's got to be based on that. And if we didn't have this distinction in looking at the facts between the prejudice standard and the actual innocent standard, there would be no reason to have 2 separate exceptions to procedural default. Otherwise, they would conflate into one. And so that's why Frady, Your Honor, finds that the prejudice standard has to be that it worked to his actual and substantial disadvantage. Here, Mr. McClammy was convicted of a second 924C count, which not only required a mandatory sentence, but at the time required a 300-month consecutive mandatory sentence. And I see my time is up.
Where do you find actual innocence of this bank robbery in view of the guilty plea, which specifies so many of the salient facts?
And I see my time is up. May I answer the court's question?
Why don't you go ahead and just reserve it for rebuttal, would you mind?
Thank you, Your Honor.
All right, we'll hear from the government here.
Good morning, and may it please the court. Jacqueline Bashara for the United States. When the defendant pleaded guilty to count 4, he admitted in the statement of facts that he aided and abetted a bank robbery on July 10th, 2012, and that he discharged a firearm during that bank robbery. So whether the court resolves this case through the lens of procedural default or on the merits, the defendant is not entitled to vacator of his 924C conviction.
Well, I'm curious as to, did you handle the co-defendant's 2255?
I did not, Your Honor.
Do you have any knowledge of how he got relief?
I don't know, Your Honor. I understand that those proceedings occurred before the proceedings in this case. As best I can tell, that was a mistake in terms of the government's response there. But for the court's reference, to the extent the court is concerned about some kind of unfairness between co-defendants, what happened after the co-defendant's conviction was vacated was that he was ultimately resentenced, and the court simply increased his sentences on the remaining valid convictions. So now that co-defendant is serving a sentence of 420 months, which is just 12 months shorter than Mr. McClammy's sentence in this case. But in any event, of course, I'm sure the court is aware that the district court, in making a factual determination of what the predicate supporting count 4 was not bound by the government's concession in another case, right? It is, as this court said in Saeed and Ali, this is a fact-specific, case-specific assessment that really turns on the record documents
But
here.
didn't the district court just misread this? You know, you have cause and prejudice and other good arguments, but it pretty clearly says count 4 is the crime of violence is conspiracy in violation of 1951A.
As specified
that
in
be any
Overt
clearer?
Act 6.
Right, and says conspiracy is in violation of 1951A, and you agree with me that's the Hobbs Act, right?
Of course, yes.
As charged in count 1, overt act 6. And you have to have that overt act 6 to make clear that it's not the overt act that's charged in the other 924C, to make sure that it's not the same predicate act in both counts, right? That's why you had to specify the overt act.
That's correct.
Right.
Yes.
But that doesn't mean that it's the predicate's bank robbery. It just means you had to specify what the overt act for the conspiracy was.
Perhaps, Your Honor, but I think the other documents in the record support the district court's determination. And given that this court is reviewing a factual finding for clear error, when there are two permissible views of the evidence,
There's definitely not two permissible views of how to read this, but you win for other reasons, right? Like you have your procedural default arguments, et cetera. But I don't see a straight-faced argument that this is a bank robbery predicate. The bank robbery statute is just not mentioned here.
But it is the 924C is specifically identified as occurring on July 10th, 2012. And we know that it's a discharge. It's not just a use of a firearm in furtherance of an overall conspiracy, right? If you think about this court's reasoning in Saeed, for example, where the defendant argued that the jury could possibly have convicted him of 924C and 924O offenses based on the conspiracy offenses of which they found him guilty rather than the substantive offenses. And this court reasoned that there was just no reasonable probability that the jury could have found him guilty of, looking specifically at the evidence adduced at trial was based on a particular offense in April 2010, an attack against the U.S.
We're just reading a document. This was a guilty plea, and he pled to what's written here. And the reason you have an overt act is because it's conspiracy, right? Conspiracy, you have to specify what the act is. It doesn't make the act the predicate offense. Conspiracy is still the predicate offense.
Your Honor, we would dispute that, and we rely on the district court's factual finding, especially given the admissions in the statement of facts and at the plea colloquy that this was a discharge of a firearm during the bank robbery.
Right. He admitted, and he admitted the overt act 6, right? That he robbed a bank with a gun. That's why that's a valid alternative predicate. But it doesn't change what the document says, right? That the predicate is conspiracy under 1951A. We don't have to dwell on this, but I don't buy that argument. But you have other good arguments you may want to talk about.
Of course, yes. I'm happy to discuss the procedural default arguments if that would be helpful.
Sure.
So just to respond to my friend's point, we do dispute that the defendant has established novelty sufficient to establish cause. We know that from the Supreme Court's decision in Bosley that this kind of claim it just does not rise to the level of cause. Both the
I thought
Fifth
it's
Circuit.
cause if the Supreme Court explicitly overrules its prior decisions. Hasn't the Supreme Court said that's cause?
Well, that was in Reed v. Ross, which predated Bosley, and the Fifth Circuit in Vargas Soto reasoned that Bosley really limits the force of Reed v. Ross and kind of narrowed the scope of what does constitute novelty. I think the defendant is sort of characterizing this as a species of novelty that turns on futility, but both the Supreme Court and this court have repeatedly rejected the argument that futility rises to the level of
but
cause,
Bosley,
right?
I mean, Bosley's saying that it wasn't novel because the court hadn't ruled on it definitively, and the federal reporters were full of cases where people were raising this sort of challenge, right? What's going on? But this issue, Like people challenged it all the time, but the Supreme Court had definitively rejected their arguments. So isn't that pretty different from Bowlsley?
Not quite, Your Honor, because if you look at the Supreme Court's more recent decision in Greer, understandably, that's in the context of plain error review, but the Supreme Court rejected the defendant's argument that some kind of exception to plain error applied because every court of appeals before Rehaif had held that 922G doesn't require knowledge of status. And the Supreme Court said that's still not enough to show some kind of exception for utility or novelty. So if that's true in the plain error context, it must be true here on collateral review where the standards are that much more onerous.
You don't need us to rule on that ground, right?
We don't know, Your Honor. It's enough for this court to find that the defendant cannot establish actual prejudice for the reasons that I believe both you and Judge Wilkinson were noting. There's just no reasonable probability the defendant wouldn't have pleaded guilty if the government had simply sort of reformed or relabeled the predicate here. We know that because the defendant hasn't come forward with any evidence in the record that this was sort of the predicate was determinative of his decision to plead guilty. Further, under this court's decision in Puget, we can look at circumstances like first of all, the evidence that likely would have been presented at trial as stipulated in the statement of facts, and as well as the potential for additional charges, right? I mean, we know at JA 55 to 56, the defendant admitted to his participation in a total of 6 armed bank robberies, which if he had proceeded to trial, he could have faced a significantly higher mandatory minimum if the government had charged each of those armed bank robberies as separate 924C offenses back in 2014 before the First Step Act. And so that is a sufficient ground for this court to affirm the district court's ruling. I'm happy to talk about the Borden issue at this point, unless the court has other questions about procedural default. So briefly, just to confirm, Borden never held that the force clause requires specific intent. No court of appeals since Borden has understood Borden to hold that. In fact, the en banc panel of the Ninth Circuit in Begay actually understood that Borden abrogated the Ninth Circuit's precedent to the extent it had previously suggested that specific intent was required. It would also be really difficult to square that understanding of Borden with this court's recent decision in Manley, where the central issue was whether extreme recklessness satisfies the force clause. We know extreme recklessness is necessarily a lower level of culpability than knowledge. So if it was determinative, basically, if extreme recklessness is sufficient to satisfy the force clause, so is knowledge. And more recently still in Boyd, this court confirmed that Borden simply confirmed this court's existing precedent going back as far as Garcia versus Gonzalez and McNeil and Middleton. So knowledge continues to satisfy the force clause, and Borden did not abrogate McNeil, so bank robbery remains a valid predicate under 924C. If the court has no further questions, we ask that you affirm.
Judge Reising, do you have any further questions?
No, thank you, Judge Wilkinson.
Judge Floyd?
Your Honors, I first want to point to this court's decision in United States versus Jackson, which in a very similar procedural posture to what Mr. McClammy finds himself in, found that there was no procedural default. So that is our position. There is no procedural default in this case. If this court finds that there is procedural default, as Judge Rushing noted, Reed versus Ross is the governing standard here, which clearly identifies 3 separate ways that a claimant can overcome the cause portion of procedural default. And Johnson explicitly overruled its decision, which was overcoming a mountain of lower court authority in the opposite direction in James. And so we meet the cause standard, I think, easily. In terms of the prejudice, I again want to emphasize that the correct standard that this court has to look at is not based on the facts when we're talking about prejudice. What we're talking about in prejudice is did the error that the court incorrectly identified the predicate here as Hobbs Act or as bank robbery, as opposed to Hobbs Act conspiracy? Did that error work to Mr. McClammy's actual and substantial disadvantage? Here, the answer to the prejudice question has to undisputably be yes. because when we look at what happened, Mr. McClammy is convicted of a second 924C. He gets a second or a consecutive 25-year sentence because there are two 924Cs. And that is not what we do in this type of prejudice analysis, is go back and look at what would the government have done. They may have just substituted. That is a path of an inquiry that I think is fraught with concern, because we don't know exactly what the parties would have done, given if the law at the time now was in effect at the time then. But in terms of the question, Your Honor raised, Judge Wilkinson, in terms of what is the basis for the actual innocence claim on count 4, I want to make sure that I'm clear about what our argument is. In terms of actual innocence on count 4, if this court finds that the 924C charge in count 4 is based on Hobbs Act conspiracy, as I think this court must, then we have to look at that is not a crime that Mr. McClammy could be convicted of.
One thing I'm concerned here is that we may be missing the forest for the trees. It seems to me that in the plea agreement and the plea colloquy, you have an individual that has admitted the predicate act to count 4, and he's admitted to bank robbery at a particular time and at a particular place. It doesn't seem to me that discharging a firearm in the course of a bank robbery to which he is admitted that seems to me a valid 924C predicate. And we can go through these different the different contortions and things that you have respectfully laid out for us, but at the bottom line is that he is admitted to what did Congress pass this statute for? It passed this statute for 924C to curb the discharge of firearms in a crime of violence. And there doesn't seem to be any question that he was aiding and abetting the discharge of a firearm. That hasn't been brought up. And there doesn't seem to me really any question that the bank robbery, an armed bank robbery, is anything less than a crime of violence. So when I come right down to it, it seems to me you've got a perfectly valid predicate to count 4, and that it's right in the heartland of what Congress was trying to do with 924C, and that is to put an end, or to rather to impose strict penalties for the discharge or use of firearms in connection with a crime of violence. And that's what's here by the Mr. McClammy's own admission. That's what we have, is it's a classic 924C.
And I see my time has expired. May I answer the court's question?
Sure. Mm-hmm.
So, Your Honor, the issue I think that the court has to confront, and the court's concern that the court just addressed, is that in Boosley, when the Supreme Court in Boosley said that we have to look at the facts to determine whether there is actual innocence, it limited itself to the crime charged. And so what we have to look at here is that the crime charged in count 4 was the conspiracy to commit Hobbs Act robbery, which we should all agree is not a crime of violence. And that is what this court must find. I urge the court to vacate this conviction in count 4 and remand the case for resentencing in district court.
Well, I guess my only response to that is that you seem to come close to saying that actual innocence requires some kind of separate charge and conviction on 924C. And you know, and I know that it doesn't require that. It's enough that a reasonable jury could convict on it. And it's hard to see how it could not convict on it when the admission is made during the stipulation of facts as to by the individual himself in order to get a good deal on a plea agreement, that there was this participation in this particular bank robbery. Of course, a reasonable jury could convict on that.
I appreciate the court's comments.
I'm happy to give you the last word.
Thank you, Your Honor. I think
I'm
we may disagree about what the law requires, and I think the law requires that in the prejudice standard, we have to look at what the count is that is charged, and that clearly is conspiracy here, which means that Mr. McClammy is actually innocent of the 924C in count 4. Thank you.
Thank you. All right. We will proceed into our next case, United States versus Southern Coal Corporation.
My name is Rob Fowler, and I represent the appellate Southern Coal Corporation and Premium Coal Company, and I'll refer to them throughout my argument today as Southern just for ease of purpose. Southern asked this court to address a very narrow issue, and that is, did the district court err as a matter of law in its interpretation of a 2014 consent decree and finding Southern liable for stipulated penalties for alleged general violations of the Clean Water Act?
Let me get one point cleared up at the beginning. Do you all agree, and I'll ask it to the other side too, do you all agree that consent decrees are interpreted according to normal contract principles? And if so, which state's contract law applies in this case?
Yes, Your Honor. Two thoughts. I think all the parties agree that contract law applies, at least in the briefs and up until this point. Because the contract occurred in Virginia, it's Virginia law, but you'll see that Virginia law actually pretty much follows the federal law as well. So I don't think that there would be much of a difference either way, because they follow the precedent of U.S. versus Armour and whatnot. So I don't think that that would impact anything otherwise. The answer to this question, though, the issue is the district court did err, because there is absolutely no language. I'm going to say that again. There is absolutely no language in the consent decree, and especially in the paragraphs identified by the government, that even mention the word Clean Water Act. And since there's a complete lack of any language whatsoever regarding the Clean Water Act, you can see that the district court's exercise was not an exercise in plain language interpretation. Rather, it turned to aids of construction that have been specifically rejected by the United States Supreme Court. The Supreme Court explained the importance of this appeal in United States versus Armour at 402 U.S. 673 in 1971. And it explained that because decrees are, because the defendant has by decree waived his right to litigate the issues raised, a right guaranteed to him by the due process clause. The conditions upon which is given that right must be respected, and the agreement must be construed as it is written and not as it might have been written had everything ended up in full litigation. The Supreme Court saw this issue as a due process fairness issue.
Let me ask you about the permits and the requirement to keep a permit. The consent decree has a number of provisions that are based on or keyed to a permit, right? Like the the effluent discharges, right? They have to be kept below permit levels. The sampling has to be done as per the permit. There's a number of requirements that have to do with staying within your permit. And then you have paragraph 29 that says, when compliance with any obligation requires a permit, you have to make sure that you're timely applying and keeping the permits. So why doesn't that resolve the question of whether the consent decree required Southern to apply for and maintain permits?
Yes, Your Honor, there's a couple of answers to that question. First of all, the answer is that NPDES permits, all of the NPDES permits here, there's only 3 allegations, so a total of $3,000 stipulated penalties come from a violation of the NPDES permits, the requirement in the permit. And by the way, the allegation says that they shall timely apply for a permit. And because they didn't, the permits expired on one date. And then after that, there were violations. In fact, the government is briefed at page 5.
But what else? What the consent decree uses over and over the word permit in paragraph 22, paragraph 29, I think ported paragraph 47, 45. And what else could that mean other than the CWA permits? And the what else could it mean other than those permits? Is your problem that they don't put CWA permit in front of it? We don't put CWA, those initials, in front of the word permit?
Your Honor, that's and piggybacking off of what Judge Rushing's comment was, and that is correct, but there is a very big distinction between a violation of an NPDES permit and the Clean Water Act.
Well, I didn't ask about that because I agree with you. There's a difference between violating a permit and violating the Clean Water Act. What I'm asking is, why can't I tell that you were required to keep a permit, right? Your client also was fined for not keeping a permit, not maintaining a permit. And it seems like the consent decree, as Judge Wilkinson was pointing out, has all sorts of obligations that have to do with complying with your permit. And then paragraph 29 says, if you have to comply with a permit, you need to make sure you're applying for it and maintaining a permit.
Your Honor, paragraph 29 actually isn't even talking about NPDES permit.
How do I know that?
I'll tell you how you know that, Your Honor, and that is paragraph 29 imposes a procedural requirement. In fact, every single paragraph in section 6 imposes procedural requirements that require a trigger, a condition precedent before they're applicable. Paragraph 29 says when work obligations require something, then you must apply for the permits. And the permits here it's talking about, we have a perfect example. The government sent a letter after its demand letter to Southern, and Tennessee sent a letter and said, guys, let me tell you how this works. And they said, you have to do some injunctive work in Tennessee. And while you're doing that injunctive work in Tennessee, keep this in mind. If you disturb greater than 5 acres and fixing the site, you have to get a stormwater permit.
Yeah, it might cover those permits too, but it wasn't the district court right in saying, if this consent decree doesn't include a requirement for you to maintain a permit, then it requires almost nothing, because so many of these obligations have to do with making sure that your discharges are below permit levels. You're sampling in accordance with your permits. And if Southern can say, well, we just stopped applying for permits, no problem, no consent decree violation. Isn't that a little backwards?
No, Your Honor, it's not backwards because it's the way the court is intended. And let me tell you, I think it's important to understand how Section 8 operates the financial assurance, because it actually fixes the exact problem you're talking about. Section 6 provides for financial assurances. And the way that it worked, it required 2 things of Southern. They had to establish a $4.5 million line of credit, and they had to establish a trust. And the way that section operates now is, if the government believes, and there's 2 different categories under 63 of work. There's the work that's required by the consent decree in section 6, 7, and 9. And then it says, and additionally, in any additional requirements And the additional requirements talks about the NPDES permitting.
I understand either party's incentives in this case, because the penalties under the Clean Water Act seem to be more harsh than the consent decree. And then why would you want to get out from under the consent decree if that's true?
Your Honor, the reason would be that we believe that the delays in obtaining the permits weren't our fault. We believe that the state's delayed and we're getting penalized because the state wouldn't issue the permits on time. We were late in applying for them, but then it took them 2 years to apply to then issue the permit. So we think we would be better off with an original action, which is an option that the government had.
Hey, in other words, let me make sure. You don't want to be bound by this consent decree. You want the Clean Water Act provisions applied to you?
Under these facts, the answer is yes. I think that, and the reason is because that's not the agreement we reached, Your Honor. And that goes back to Judge Rushing's question. If you look at the way 63 works, it gives a solution to the problem of, well, this is going to be an absurdity. And the way that it gives that an option is they established a $4.5 million line of credit. They had to still establish a trust. If the government wants any of the things done that's in the definition of work,
but listening to you, where you're going is the way you want to interpret this consent decree is it would leave the waters of the affected states in worse condition than they were before suit was filed. And you're reading it also in a manner that gives you a green light and free license to violate the Clean Water Act almost in perpetuity. I mean, it seems to me that the overall thrust of your position is to leave the Clean Water Act and the efforts that have been taken to enforce it in tatters.
Your Honor, the answer is that's simply not the case. And the reason is the consent decree has been in place for 5 years. In fact,
but let me just, what reason is there to refer to these permits if they didn't involve applying for the permit, and once you got the permit, complying with the permit? That's where all of these, every one of these provisions are directed toward permit compliance. And also, you knew going in here that the whole structure of the Clean Water Act is built on permits. That's the way the act works. And what you're saying is that the central and operative provision of this statute has no application, notwithstanding the repeated references to your obligations with respect to permit compliance. I don't understand in just a few words of plain English what is deficient about this consent decree, or how it can possibly be interpreted in a way that says, oh, no problem, you can ignore the permits at will.
Your Honor, the argument you made is the exact argument that the government made in U.S. versus Armour, and that was an anti-competition. It involved the Sherman Act, and what the government argued there is, and the facts of Armour are somewhat important here. In Armour, it was prevented from doing certain activities under the consent decree, and they were acquired by Greyhound. Greyhound acquired them. And then the issue was, can Greyhound, and Greyhound was involved in the very activities that the consent decree prevented Armour from doing. And then the question was, well, can that happen? And the government argued, even though there's not any language there, but the purpose of the consent decree was to do that. And in fact,
but what you're asking us to do is to ignore the language that's right in front of us. I guess the most direct language is in paragraph 22, and it says Southern Coal shall perform the work required by the decree, and this is in quotes, in compliance with the requirements of all applicable laws, regulations, and permits. And what you're asking us to do is to look at that and not believe what our eyes tell us. I mean, you're arguing against what is stated in the consent decree in the clearest possible language.
Your Honor, that is, with all due respect, that's not what paragraph 22 says. 22 has a condition precedent. It says, when doing the work required by the consent decree, that is a requirement. So the government's obligation is to point to somewhere in the consent decree that requires us obtaining an NPDES permit. That work is not there. All of the obligation in the consent decree, they can do most of those obligations even without a permit. So those would still be enforceable. And second, 60, the government can obtain the permit themselves through the financial assurance section. That's the purpose of it. It says that under 63, the government can go and say, here's the money, here, give it to the trustee, complete the work that's in paragraph 63. So there is never going to be an opportunity for there not to be a permit. The government has that solution, and that's the way the parties meant for that to be. And in fact, if you look at the language of paragraph 63, it divides it into two types of work. The first one says section 6, section 7, section 9. And then it says, and any additional requirements, required by the NPDES permit. The parties intended for stormwater, not for stormwater, but for NPDES compliance to be controlled by the financial assurance section. The sections of 22 and 29, those are all procedural requirements. There is not a substantive requirement in there. In fact, if you were to put 22, 29, and 63, and that was the only paragraphs in the consent decree, they would not require anything, because the first ones require condition precedents to be met. They have to point to language that says, Southern, you must get a permit. And in fact, in front of the district court, we provided 3 instances of consent decrees that had the exact language of paragraph 22 and 29. But guess what else they had in it? They had an affirmative obligation that says this: defendant shall comply with its NPDES permits. Defendant shall comply with the Clean Water Act. There's none of that language here because the parties intended for compliance with NPDES permits to be covered through the financial assurance section and not otherwise. Now, if you
in addition to paragraphs 22, 29, paragraph 47 actually goes so far as to set forth the requirements and the necessity for monitoring compliance and implementing responses when you're out of compliance. And then paragraph 63, 63, says defines work as broadly taking all necessary additional actions to comply with the defendant's NPDES permits for the term of the consent decree. And the problem you have is that this, not just in one place, but over and over and over, the requirements of monitoring violations and complying with requirements are mentioned. I mean, there's a drumbeat of language in this consent decree necessitating compliance. And I find it hard to believe that you entered this kind of consent decree with any other understanding or expectation.
Your Honor, again, I would point to Armour, and the reason is because that's the exact same argument that the government made, that there was no language that required or prevented Greyhound from purchasing. And they said even though the entire consent decree is about the Sherman Act, even though it may prevent it, and maybe even use its words, even though you're asking us to do it's going to result in the same evils, and that's the word that they use in Armour. Even though it's going to result in the same evils, the language isn't there. And if the language isn't there, the government can bring an action under the Clean Water Act. And in fact, if you look at all of the requirements for the NPDES permit, we agree with that. And
all right, Counsel, you have some time for rebuttal, and I'll ask my colleagues if they have any question. Otherwise, we'll prepare to hear from you in rebuttal. Okay?
Yeah.
Do either of you have any questions?
No.
Mr. Frankel?
Thank you, Your Honor. Good morning, and may it please the court. David Frankel on behalf of the United States. So the consent decree here was reached after extensive negotiations between the parties to resolve allegations that defendants had committed systemic, massive Clean Water Act violations. Included among over 23,000 plus individual violations were numerous violations of unauthorized discharge without a valid NPDES permit in place.
Can I ask you a kind of a clarifying question about the penalties here? It seems like there are a few different categories, right? There are penalties for not maintaining a permit. There were penalties for discharges in violation of a permit, and there are penalties for unpermitted discharges, and those are all different bases, right?
That's right. There are daily violations for those three different categories here.
And the decree defines the effluent limit violations in terms of the permit, right? So if a discharge is made in excess of what's allowed by the permit, then that's a consent decree violation.
That is one kind of violation of the consent decree, yes.
And if a facility doesn't have a permit and it makes a discharge, that's not a violation of a permit, right? That's a Clean Water Act violation.
It is a Clean Water Act violation and also a violation of the consent decree, which anticipates that defendants will have permits. They will attain and maintain permits at all of their discharge locations.
That's my sticking point, is where in the consent decree does it require, or I guess prohibit, Southern from making unpermitted discharges?
So if they make unpermitted discharges, then among other things, it is a violation of the underlying laws, that there are the Clean Water Act, as well as the state laws, that the state law cognates to the Clean Water Act require that permits be in place and that there be no unauthorized discharge pursuant to those permits.
Right, but we agree, right, that it's different. It's different to have a discharge that violates a permit versus a discharge, an unpermitted discharge. Those are two different things under the Clean Water.
They are different things under the Clean Water Act. And I would say there's numerous provisions here that presuppose that an NPDES permit will be in place. And so if there's any action that occurs, including an unauthorized discharge without an NPDES permit in place, that is a violation. In paragraph 47, for example, talks about a whole set of actions that discharges have to comply with applicable NPDES permits. So if there's not an NPDES permit there in the first place, then any discharge at all is a violation of the obligation of the consent decree.
If the consent decree says you have to comply with your permits and discharges have to be below the permit level and the applicable permit, that's what it says, but you don't have a permit, then there's no applicable permit, right? Isn't that kind of obvious?
Well, I do think it's helpful to step back for a second here. And the consent decree was designed to encompass violations, including violations of unauthorized discharge without a permit. And I think it makes sense to interpret the decree, to interpret the scope of the decree and the scope of the decree's coverage, commensurate with the scope of violations that led to the decree. This is context and circumstances that this court is perfectly capable of considering. The consent decree itself specifically talks about the complaint and the underlying violations in several places. And so I think this is all.
It deals with those violations in a certain way, right? It has paragraphs and paragraphs that lay out the obligations. And this doesn't resolve the whole case, right? The consent decree can require them to maintain permits and to comply with those permits. But there's kind of a separate question of, well, if they don't have a permit and make a discharge, what in the consent decree requires them to kind of comply with every obligation of the Clean Water Act, regardless?
Sure. So I guess I would parse this out in a few different ways. I think, first of all, Your Honor is making an argument that is not an argument defendants have made. The defendant's argument, as I understand it, is that they have no obligation to maintain Clean Water Act NPDES permits. They have not made an argument that even if they had to, then.
I mean, your friend on the other side just said nothing in the consent decree requires says you must comply with the Clean Water Act, right? And every Clean Water Act violation is a violation of this consent decree. Instead, it says when you're performing the work required, you should comply with various laws. But there's really no argument that that's an independent freestanding obligation to comply with all federal and state laws. Like, it's not a consent decree violation for them to make a misstatement in a securities filing, right? That would be an exaggerated reading of paragraph 22.
Right. No, I think that's fair. But again, paragraph 22 does talk about all applicable federal, state, and local laws, regulations, and permits. And so there is one obligation that goes to the NPDES permits that the decree is replete with saying that the specific facilities and outfalls have to have. But there is also an underlying obligation that they comply with all applicable laws when doing any work under the consent decree.
How much of a problem or actual or practical problem are we dealing here where something is in compliance with a permit, but at the same time is not in compliance with the Clean Water Act? Is that likely to be the case, or is compliance with the permit by and large sweep in the great majority of discharges?
I mean, I think it sweeps in really everything relevant. The only issue would be if there is not an NPDES permit that is in place, there is an argument that there is no permit obligation not to discharge. At least that's how I understand Judge Rushing's argument. But that, aside from that discrete, and then again, that would be 3 of the daily violations of really a vast array of violations that are underlying the multi-million.
But I mean, I understand what their argument is that they're not, the restriction that under which they chafe was the permitting restrictions. And as I understand their argument, it is really essentially aimed at, we don't want to have to comply with all these permits and the monitoring of them and the discharge of them, because the permits themselves really express in the most precise manner what the defendant's obligations are. I realize paragraph 22 has broader language, and it could be read. It could probably be read to prohibit any Clean Water Act discharge, which is permitted or unpermitted. But as a practical matter, they don't want to have to abide by these permits, and that seems to me what they're aiming at.
That's right. That is the heart of the decree, is attaining and maintaining compliance with NPDES discharge.
The other thing is, as I understand it, for purposes of this appeal, we're not really dealing with remedies and damages and the rest. That hasn't been, as I understand it, brought into question as much as whether the consent decree itself requires permitting compliance. Am I correct in that?
That's right, Your Honor. The defendants in this case do not challenge the numerical amount of penalties imposed. I would say that their only alternative argument that arguably gets in this realm is they say, well, maybe during the period these NPDES permits were active, they required renewal, so we would have 3 daily violations for renewal, but nothing beyond that. I mean, defendants' whole argument is that they had no obligation to maintain NPDES permits in place. That they don't quibble what happens beyond that.
If we affirm or if we were to affirm the district court on that basic question,
Yes.
which is the permitting obligations and permitting violations, would there not be a number of remaining proceedings before the district court dealing with the exact amount of damages or the exact amount of penalties, I might add, or exactly what the status of non-permitting obligations of non-permitting obligations were? I mean, what I'm looking at is, would an affirmance here wrap the case up, or are there still additional proceedings before the district court that we would have to that would have to take place. What do you say on that?
There is nothing else required that this court, in affirming the decision below and affirming the district court's reasoning below, that would wrap up the entirety of the case. There really has not been the type of penalty by penalty dispute or disagreement with the amount of penalty.
Okay, and you're saying we would wrap up the entire dispute because these other things have not been brought into play by virtue of the appeal.
That's right.
So your incentive to stay under this consent decree is it just, as y'all just said, it just wraps up the whole thing and there's nothing left to do.
I'm sorry, can you repeat the question, Your Honor?
Well, I'm trying to figure out what your incentive is for staying under this decree.
Mhm.
Because if you proceeded under the Clean Water Act and
Mhm.
other statutes, you got much more, you
Yeah.
got a much bigger hammer in terms of penalties.
Well, that's right. I would first note that proceeding under the consent decree is not an exclusive remedy. So we don't waive any right to go after defendants for Clean Water Act violations. But in theory, at least, proceeding under the consent decree should be a more streamlined, easy way to obtain penalties for violations. I mean, we're caught up, I think, in this attempt to obtain an end run around the consent decree with the arguments that defendants are making here, which is why this has turned into the ball of wax that it has. You know, but at least in theory, that proceeding under the consent decree should be a quicker, more streamlined way to get penalties, which is why we did that in the first instance. But certainly we still have available to us, no matter the outcome of this case, going after them under the Clean Water Act as well. You know, I do think that Your Honors appreciate the argument that we've made in terms of how to read the decree. I think it might be useful just to quickly walk through one provision just to give a more granular understanding of how we're reading paragraphs 22 and 29. So one of the obligations in paragraph 45, and this is at J 129, says defendants shall conduct outlet inspections as required by the NPDES permits applicable to such sites. So performing outlet inspections as required by the applicable NPDES permits is, in the words of paragraph 22, work required by this consent decree that can only be performed in compliance with all applicable laws and permits if an NPDES permit is in place. Then paragraph 29, because this is a compliance obligation under the decree, invokes a requirement that defendants submit timely and complete applications to maintain those permits in place. I did also want to quickly talk about defendants' interpretation of paragraph 63 as sort of an alternative remedial scheme in this case. First, it's just an important admission. They agree that paragraph 63 requires that they maintain NPDES permits in place, but their argument is that work, and this is capital W work, is something other than a requirement of the decree. And first, stipulated penalties accrue for any violation of any requirement. So if 63 imposes any requirement, then it too would be a grounds for daily penalties. And I point this court to the language in paragraph 67, which specifically says that the failure to perform the work puts defendants in default, it leaves them deficient, and if defendants, once they're advised of a default under paragraph 63, they must perform the prescribed work. So this suggestion that paragraph 63 describes things that are not requirements of the decree is just wrong. Things that are required under paragraph 63, if not done, are also breaches of the decree that give rise to stipulated penalties.
One thing you mentioned in your brief, you say Southern Coal's observation that paragraphs 22 and 29 do not explicitly mention the CWA or permitting is unpersuasive, but you know, they do mention permitting. I mean, I don't understand the argument here because the Southern Coal is saying, well, they don't mention permitting, but that's just flatly wrong, isn't it? I mean, those sections that they reference do mention permitting.
Yes, the decree is replete with requirements that defendants obtain
So
permit.
how can it just be unpersuasive? It's just flatly wrong. isn't it? I mean, because what other permits are there? I mean, are we talking about Martian permits?
No,
I mean, the only permit that could be would be a CWA, wouldn't it?
that's exactly right. I mean, if there is one permit that is unequivocally required, it is the Clean Water Act NPDES permits. That is the heart of the decree. That is the basis from which all of the obligations on the decree depend and explicitly talk about. That's right.
I mean, that's the foundation stone, isn't it, to the Clean Water Act?
It is. The entire premise of the Clean Water Act is to make sure that discharges only occur in compliance with valid NPDES permits. And it's an end run around the Clean Water Act, and it's an end run around this decree, which was designed to resolve systemic Clean Water Act violations, to suggest that they can get out of their obligations by failing to timely renew their Clean Water Act permits.
I mean, it seemed to me that their argument was that this consent decree, the lengthy negotiated consent decree, amounted to nothing. And I can't see what obligations they say they are under. They're quick to tell us what obligations they're not under, in their view. But they have no reading to say we recognize that we do have certain obligations and here's what they are, but they don't say that.
That's right, Your Honor. I entirely agree. I'm happy to answer any further questions the panel may have.
Judge Rushing, Judge Floyd, do you all have any further questions of this gentleman?
Yes, sir.
All right, let's move. Let's hear some from Mr. Frankel in rebuttal.
Yes, Your Honor. Let me start by saying this. Southern is not trying to get out of the consent decree or the permits. In fact, we have 172 permits. That's in the record. We had a manager that mistakenly missed deadlines to file 4 or 5 permits, and then we filed those permits, and they were subsequently issued. Out of the 172, we still have them. We're not trying not to comply with permits. We filed the applications. We have them. Also, under Section 63, if we didn't, the government can give the money to the trustee, and the trustee has to get the permits. There's no way that we can get out from under these permits. That is not what the argument is. The argument simply is, and we're spending a lot of time on NPDES permits, and I think Judge Rushing pointed out, our argument has to do with the Clean Water Act. Once those permits expired, they were nullities. They were legal nullities. You cannot violate a permit that no longer exists. Every single violation that they point out, except for 3, happened after the date all the permits expired. So they have to be Clean Water Act violations. Now, if you look at paragraphs 22, 29, and 63, Clean Water Act is not mentioned a single time. In fact, it's not mentioned in the entire section.
Well, do you agree that there's penalties for not complying with the permits, which are the 3 you're talking about? Then there's penalties for not having a permit. And then there's penalties for unpermitted discharges, things that you did without a permit that violates Clean Water Act. So those are 3 different categories, right?
That's correct.
Okay.
And the first one is a failure to renew permit, arguably is a violation of the NPDES permits. The other 2 only can be classified as Clean Water Act violations. And if you look at the language of the decree, not only do the paragraphs that the government points out saying we violated, they don't even mention the decree. They don't mention applicable environmental laws, which is a defined term in the decree that includes the Clean Water. So it's not even mentioned a single decree in the entire sections. And yet they're saying somehow the decree imposes an obligation to follow the Clean Water Act. It does not. It's the same exact argument that was made in Armour and was rejected in Armour. Your Honor, with my few seconds that I have left, point out a couple of things. Number one is the district court specifically relied on his subjective view of purpose. He stated that he didn't accept our argument because that would defeat the entire purpose of the consent decree. That's the exact argument, again, in Armour. And this court has specifically rejected that and found it in complete error in Consumer Finance Protection versus Clock at 957 F3rd 545, saying that that is an error. And in fact, you'll find out throughout the argument, yes, NPDES permits are part of it. We will comply with our MPDS permits, but we can do that because the MPDS permits will always be in place. I see that my time has expired. We ask this court to.
All right, thank you. Thank you very much.
Thank you.
All right, we will proceed into our final case.
Good morning. May it please the court. Jay Marks on behalf of petitioner Julio Sosa Uvalle. I'm very pleased also to introduce to the court his family, who's here today, his wife and child. Your Honors, the immigration judge and the Board of Immigration Appeals erred in multiple instances in this case in finding that, well, on the immigration court side, that petitioner's violation of 8301C1 of the criminal law article of the Maryland Code was a crime involving turpitude. The Board of Immigration Appeals erred in failing to address this issue completely on two occasions. 8301C1 is simply not a crime involving moral turpitude. Using the modified categorical approach, it has no fraudulent intent. It can be committed by giving false information to a private individual, as Mr. Ishola did in Ishola v. State, as we raised in our briefs. It makes no mention that the false statement has to be made in the course of law enforcement action or a police investigation.
I don't want to derail you, and you can come back to this, but before we get into the merits of that argument, you agreed that the board didn't rule on this. The board, your argument was the board skipped a step that's required, right?
That is correct. They skipped a step that was required.
And you're familiar with Chenery, which says we can't rule on a basis that the board didn't rule on.
Well, Your Honor, we're actually looking at, and our position is that I Hua Chen v. Holder at 742 F 3rd 171 allows this court to look both at the board and the IJ's decisions when the board adopts the IJ's and affirms the IJ's decision, but supplements.
But it didn't adopt that part, right? It didn't adopt the CIMT analysis. And there arguably the board could have, what it did was said, you have to have a waiver and we find you don't qualify for a waiver. It could have instead skipped the CIMT analysis and said, we are going to deny adjustment of status on discretionary grounds, just as a matter of, even if you qualified, we're going to deny it as a matter of discretion, right? So doesn't that counsel against us ruling on the legal issue? We could say, this is not a CIMT, and it goes back and the board says, regardless, we're still going to deny it adjustment on discretionary grounds.
So allow me to address the issue of this court's authority to address the CIMT in the first instance.
Okay, but before that, do you agree that no matter what we do, if it goes back to the board, they can still deny adjustment on discretionary grounds?
They could.
And the factors that they consider are the same as the factors they consider for waiver inadmissibility.
But here's what would change.
Do you agree that the factors are the same?
The discretionary factors are the same, but
okay.
The CIMT definitely creates a thumb on the scale against discretion. the existence of the CIMT, and our contention is the mistaken conclusion that it's a CIMT, is a thumb on the scale against a grant of the adjustment application, the waiver and then the adjustment, or the application for cancellation removal. The thumb on the scale is in the negative equities, we are going to look at the CIMT as a big negative equity. And that the entire need for the waiver would be eliminated. And we would just be looking at an adjustment application with all of the equities, the family, the medical, the child, the emotional state of the child, all of these things. And we would be looking at the convictions as negative equities, but they wouldn't require a waiver. There would not be yet an additional hurdle. So while the court is correct, discretion is discretion, whether it's discretion in a waiver or it's discretion in adjustment. The presence of the CIMT is the 900-pound gorilla that is causing really the big problem here. And that we could get to a new calculus of equity balancing without the CIMT that could lead to adjustment.
But how do we get to the, how do we hold, in your view, that this is not a CIMT?
Three points that we'd like to raise. The first is that the Nunez-Vasquez decision is so close here that it points the way. It's the North Star here that clearly illuminates the correct conclusion. And the two statutes are so similar that it would truly be an injustice to remand again to the board. That would happen the third time.
Excuse me, counsel. I don't necessarily see the two statutes as being identical, and the point that was emphasized in the Nunez Vasquez case was that there could be a false expression of identity in the private sector to simply a cashier. And it doesn't seem to me the text of the Maryland statute can be read to impose criminal liability under this statute for a false representation or a false claim of identity for a, say, a Target or Walmart cashier. It says in order to avoid, assuming the identity, to avoid identification, apprehension, or prosecution for a crime. So it doesn't, so I'm still wondering how you get to the idea that if you assume someone's identity, and we're talking about identity theft here, if you assume somebody's identity in order to avoid prosecution for a crime, that's certainly an affirmative act of concealment, and it has a mens rea of knowingly and willfully, and in addition to that mens rea, I don't understand why this wouldn't be turpitudinous to assume steal somebody's identity in order and represent some of a false identity in order to avoid prosecution. Why isn't that a willful commission of a turpitudinous act?
I'd like to answer both. What I hear are two questions, Your Honor, if I may. The first is Ishola v. State the Maryland statute, the Maryland case that we discuss in our briefs, clearly Mr. Ishola went to a bank and told the teller, my name is X, when his name was actually Mr. Ishola. And the result was he was prosecuted under 8301C1. This was a private actor, a bank. This was not a police officer. There was no criminal investigation happening. So he was trying to avoid detection, committing a crime, but he did it in the private sector, if you will, almost akin to going to a Walmart or a Target and telling a cashier a different name than one's true name. So it certainly is possible to be convicted under this statute for merely uttering a falsity to, say, a bank teller, because Mr. Ishola was convicted that way. The second question that I hear Your Honor asking is, why is this not morally turpitudinous? Why isn't it reprehensible? And I believe that the court, most respectfully, is conflating the way the 10th Circuit counsel does not to conflate false statement crimes with crimes that contain fraudulent intent. C1 does not contain any fraudulent intent. Now, this court clearly showed in Nunez-Vasquez, that the absence of the fraudulent intent was key to this. The Virginia statute is quite clear.
Alvarez says you're supposed to have some actual prosecutions and to illustrate your point. And have there been any Maryland prosecutions under this particular statute for a false statement to a teller?
Yes, Your Honor, Mr. Ishola and Ishola v. State.
Who?
Ishola v. State. And I do apologize, I don't have the citation here with me, but it is in our supplemental brief and in our original brief of the matter. But Mr. Ishola did go to a bank, say his name was not Mr. Ishola, used a false name, and was prosecuted under the statute. So from our perspective—
He was prosecuted under C1?
Yes, Your Honor. So from our perspective, this court also has the authority to pronounce, even though the board has decided not to, because determining whether a state statute is or is not categorically a crime involving moral turpitude or an aggravated felony for that matter is not in the exclusive province of the Board of Immigration Appeals. This is a state criminal statute, and this court routinely and as part of its authority.
But we're not obligated to do that. We're not obligated to pronounce. It looks like a little bit. It could be read as sort of a little bit like an advisory opinion, and as Judge Rushing points out, it certainly raises questions about Chenery and jumping the gun out ahead of the board, and you know that Chenery still maintains some vitality.
Yes, Your Honor, and the third thing that I would like to raise, the third reason why I don't think this court, if it decided to pronounce on in the first instance and not allow the board the opportunity first to pronounce on whether 8301C is a CIMT or not, is because the board has had at least two opportunities here, at least, to do this, and they have simply skirted it. The first time was when the immigration judge sent the case up, we filed our appeal, and for some—
I understand that argument, and it might be true, but doesn't the recent Nunez-Vasquez case give the board something that it to consider in the first instance? I mean, in those previous instances where you say the board has passed, did they have the Nunez Vasquez case in front of them?
Not the first time, but they didn't need Nunez Vasquez to make the conclusion, to reach the conclusion that 8301C is not a crime involving moral turpitude. They didn't need it because the categorical
Well,
approach
maybe
has
say yes,
long existed.
maybe yes, maybe no, but hasn't Congress delegated to the board a considerable authority in this area, and the board has detailed requirements and criteria for when something is a CIMT and when it's not? And isn't there an advantage to having some administrative consistency on this, on the interpretations of CIMTs and what is and what isn't? And the board is the one, because it's dealing with these things on a regular basis, is the best one to be able to supply that consistency.
But this court said in Amos v. Lynch and in Solomon versus Gonzalez, and I see my time is up.
No,
May I-
go ahead and complete your sentence.
Thank you very much. In Amos v. Lynch and in Solomon versus Gonzalez, this court said that questions of whether a state statute is or is not an aggravated felony or a CIMT are issues or decisions that can be made by this court without stepping on the board's, the executive branch's toes, without violating our separation of powers.
But it's still prudential whether to remand.
Yes, Your Honor.
All right, thank you. Let me see if my colleagues have any questions. Judge Rushing, Judge Floyd, do you have?
Yes, sir.
All right, let's is this Miss Arthur? Do you let's hear your side of it.
Good morning, Your Honors. May it please the court. I'm Ashley Arthur on behalf of the Attorney General of the United States. Remand is an appropriate vehicle for this case for the board to fully address petitioner's arguments and to address the IJ's determination that the conviction under Maryland's ID.
Could you put that microphone a little bit closer to you? That's going to be great. Thank you.
Remand is an appropriate vehicle in this case for the board to fully consider petitioner's arguments and to address the IJ's determination that the conviction under Maryland's ID fraud statute was categorically a crime involving moral turpitude. As Judge Wilkinson noted, this case involves a Chenery issue, which is why we prefer remand for the court to consider the CIMT issue in the first instance. Expounding any further would be a Chenery violation because there is no clear precedent from the board. So at this time, I cannot make any predictions about what the generic elements and factors would be, let alone how the board would decide the issue, what analytical framework that it could.
Can I ask you, the government filed a motion to remand originally in this case. It was 1.5 pages. And did you mention any of these reasons for remand in that motion? I don't recall hearing them. And that's not to say you can't raise them now because we denied that motion and now we're going to decide the merits one way or the other. But these would have been good points to make in your motion to remand. When those motions are opposed by a petitioner, we have to find a reason to grant it. And the government doesn't have to admit fault. I understand that. But we see a lot of motions that just say the government suggests remand for the board to consider any and all possible arguments. And that doesn't give us much to go on.
Yes, in our remand motion, we filed that remand motion because we did catch that the board skipped that threshold determination.
But you didn't admit that in the motion, right? You didn't admit any error by the board. So now we have to have argument and find the board did commit an error by skipping a required element. Even though, as we've discussed, if this goes back to the board could, as a matter of discretion, deny relief anyway, regardless of what it concludes on CIMT. Is that right?
That's correct, Your Honor. No matter what, this case is going to be remanded. If it is a CIMT, then the board already addressed the merits on the waiver. If it is a CIMT, a waiver was required. The board addressed the merits there, and there's nothing much more for the court to do in that regard. And if the court wants to do the work and reach the issue, which it doesn't have to, then it still is remanded to the board, and the board would have to decide whether the adjustment application should be granted as a matter of discretion. And we believe it's likely that the board would find that relief is not warranted here. Strongly hinted at the outcome of the case here. We don't believe this is a good vehicle for the court to reach the CIMT issue because it's strongly hinted that the petitioner in this case is not going to get the relief.
And that's the factors for denying adjustment as a matter of discretion are the same as the factors for a waiver.
Yes, so we don't know for sure why the board didn't reach the threshold CIMT issue first. So we surmise it must have been that the board is thinking it's a foregone conclusion. But because there's no governing precedent, we prefer remand for the board to provide guidance since there's nothing out there on this issue on point. And while opposing counsel believes that if this is not a CIMT, then the positive factors would somehow push the case into a grant of adjustment, the board expressly upheld the IJ's determination that the negative factors outweigh the discretion because we have tax irregularities, the ID theft conviction, public intoxication from 2017, and then 2 DUIs from 2019. So there were other factors that the agency determined weighed against discretion for cancellation or removal. And we believe this strongly indicates what the outcome of this case would be. And it's not a good vehicle for the court to have to do the work and reach the CIMT issue. And no matter what, it's going to be remanded.
So,
And what do you mean? No matter what happens, the case is going to be remanded.
Well, if the court decides that if it wants to do the work and decides that this conviction was a CIMT, the work still has, the BIA still has work to do because it would have to be remanded for the BIA to determine as a discretionary matter whether adjustment is warranted. And if it is a CIMT and that's what the court wants to uphold, and well, then there's nothing much more to do because the board already reached the waiver issue on the merits. And of course, there is a second issue in this case regarding cancellation or removal, if you want me to move on to that, which is the court lacks jurisdiction over the discretionary denial of cancellation or removal, which the board upheld.
so just to give me a sense of, is this issue an important one in maintaining consistency in the board's CIMT jurisprudence? Is it, I mean, just in practical terms, explain to me why what argues for a remand? Does the board need this for consistency? Is this important in terms of the effect upon immigration law? Just what practical considerations warrant giving the board a crack at this?
Your Honor, because we do not have clear precedent from the board about the umbrella of ID theft, let alone the nuances of this particular statute, it'd be incredibly helpful going forward in other cases, as well as this one, as to what analytical framework the board would want to work with, what it would consider an inherently fraudulent offense. We do not know what the board is thinking with this type of offense. We don't have any on-point precedent, and it'd be extremely helpful for the board to finally illuminate what we're working with here.
Excuse me, Judge Floyd, go ahead.
Or is it for the BIA?
I'm sorry, could you repeat your question?
Is your request for the convenience of the Department of Justice or the BIA?
Our request would benefit all parties, including this court and all circuits, because we would potentially now have president from the board that would illuminate what factors it considers important in these ID theft type offenses. And it's really within the board's purview to reach that in the first instance, for the court to decide potentially the generic elements and that's within the board's purview. And because this is novel in the sense that we have nothing on point, it would be probably best handled for the board first. The court doesn't have to reach issues that are unnecessary for the court to decide a case. And here the court could remand for the board to provide some illumination. And no matter what, the case would be remanded, unless, of course, the court just upholds that it is indeed.
I mean, would our decision be binding in any sense on the board?
This court's decision to remand. So if the court decides this is a CIMT, would that be binding on the board? Is that your question?
Yeah.
Well, the board usually follows the precedent of the circuit in which it sits. So that would play a part. The department prefers the board to have the first crack at these issues because it is within its purview to decide how these, and there's nothing here that's been decided yet by the board, how these offenses would even qualify as a CIMT. We don't know if they're going to decide it's a CIMT or not. There's uncertainty. It seems like a foregone conclusion. No matter what, petitioner is highly unlikely to get the relief he seeks. And so this case isn't the best vehicle, but it could still be helpful to have an unpublished, unpresidential decision from the board, and hopefully another case comes along where
how many statutes are there like this Maryland statute? Is this one of a kind, or are these are identity theft statutes written in this kind of way pretty common?
So the identity theft statute in Maryland that I'm most familiar with is the one that's the main issue here today. The identity fraud statute from 2009, which was the one petitioner was convicted of. And at the time, it's a previous version. That's the only identity fraud statute I'm aware of that criminalizes identity fraud in Maryland. I'm happy to do further research if you're curious to see how Maryland criminalizes ID fraud in other instances, but it appears that the primary issue here is Maryland statute, which states a person may not knowingly and willfully assume the identity of another to avoid identification, apprehension, or prosecution for a crime. And that's the statute petitioner was convicted under. And I'd like to point out that that statute differs from the Virginia identity theft statute, which does not have willful and knowing language. And
Your opponent says that it's still possible to convict under this statute for a statement made to a private teller. Because you could be making a statement to a private teller in order to avoid conviction for a crime.
there were several factors in Nunez that the court considered to arrive at its ultimate decision that it was not a CIMT. The court did not hang its hat on merely the private person aspect alone. The court also noted that the factors in Nunez, there was a fictitious person that could possibly be used for the false identity that doesn't exist in the Maryland statute under which petitioner was convicted, because it had to be an actual person. And the statute, as the Isola case discusses, it explains that the legislative intent was an actual person, and it goes on to explain that the legislative intent was to address victims, actual people, and they use the word victims, of identity theft. Whereas an interesting distinguishing factor with the Virginia statute is that it actually expressly provides for a scenario where the person that's the subject of the false identity actually gave their permission to have their identity used in such a fashion. So
did the board at any time have the Virginia case in front of it at the time that this was before it?
the board presumably had the entire record before it. It did not.
Of course it had a record before it, but I'm asking you whether the particular decision from this court was before the board.
The Isola case?
This case, Nunez Vasquez. Did the board have that?
I believe the board was aware of the Nunez case, but it did not get into the analysis there, if I recall correctly, because it strictly skipped onto the waiver analysis. And the waiver analysis didn't require an in-depth discussion of Nunez. So I think it really boils down to that the Virginia statute allows someone to give permission for their identity to be used this way. And when you're thinking about least culpable conduct, I think that's a distinguishing factor. And in Maryland, a requirement is you're using someone's identity without their consent. Legislative intent was to address victims of identity fraud. And in other words, the least culpable conduct here is fingering an innocent person for a crime. And these are all things that, if remanded back to the board can address in the first instance and determine what's most important to it, which facts are most important, and ultimately, hopefully, provide some illuminating guidance.
Before you sit down, I just want to reiterate my request from before that when we get remand motions, the government obviously does not have to concede error. It doesn't have to take any positions. But these remand motions that say nothing, as you've seen, are being denied when they are opposed. And I don't want to, it's not a chastisement, that may not have even been your motion, but I just want to point out kind of what happened here is then when we have argument, the government comes in and concedes error, and we have to go through this process. So again, it's not a criticism, because that's, these motions happen a lot, but I want to point out that that's what happened here, and we might be helped in the future by a speaking motion, even if it doesn't concede error.
Your Honor, I am happy to deliver that message
Thank you.
the department. I already quickly addressed the cancellation of removal issue. If there are no further questions, I will just like to quickly conclude that Nunez does not foreclose the board from finding that petitioner's conviction in the Maryland statute is a crime involving moral turpitude. given that the statutes are distinguishable, which requires remand for the board to provide further analysis. And as for petitioner asking for this court to grant remand for the grant of relief, that request is inappropriate because this court to decide adjustment is inappropriate. That is left to the agency's discretion. And we already know, because the board strongly hinted at how that outcome is going to go. And if there are no further questions, I will briefly conclude. The case should be remanded back to the board. Thank you for inviting me here today.
Thank you. Let's hear from you, Mr. Mark, in rebuttal.
Thank you, Your Honor, very much. The Maryland statute has no without consent language. It has none of that. One can be convicted under the Maryland statute, even if they collude with another to present the fake identity. In other words, with the consent of someone else, and pardon me while I remove my mask, I just realized I left it on. One can present the false identity and be prosecuted. So there is no.
You may be, counsel, you may be right about that. You may be right, and that may ultimately prevail. I just, speaking purely for myself, I think the biggest obstacle that faces us in these questions is the Chenery decision, and the fact that it retains a considerable vitality. And this is right at the heart of the board's, what the board does, both because it's been charged by Congress with an important role in the interpretation of the immigration laws, and because it has a developed jurisprudence on the CIMT question. And it's something where the administrative state, with all its problems, can still provide a nationwide uniformity to these kinds of questions that the episodic entries of the federal courts of appeals cannot. So the thing that gives me pause is that is going at this without, it seems to go against the grain of the Chenery decision in this case. That's a different, and when something goes against the grain of Chenery, it makes me feel like I'm writing a little bit of an advisory opinion. I feel uneasy about that. Nobody's cutting you out from making your arguments. It's just a question of whether the orderly way of proceeding is to gain the benefit of what the board says. We can agree or disagree with it, but at least we would be comfortably within what Chenery seems to suggest. That's the problem. You have decent arguments on the merits, in my view, but I just worry about sort of commandeering the function of the board and reversing order here. And I think we have discretion to go either way.
Allow me to add one more point to address the court's concern. What we have here is, because of a misapplication of the categorical approach by the IJ and the board's ping-ponging without addressing this issue as its role requires, this petitioner can't get out of detention. And he's been detained for over 3 years and 4 months now, far, far longer than any state court sentence he ever received. And I look to the court's decision in Suarez Valenzuela versus Holder as a way to say we can avoid a further miscarriage here of justice if we can get this court to issue a decision on the merits of.
Well, I don't know that we're talking about a miscarriage of justice here, because we're talking about whether something is a CIMT or not. But if being convicted of this particular statute, it's not an admirable thing. Whether it's ultimately judged to be a CIMT may be one thing, but being convicted of identity theft, whether it's a CIMT or not, is still a very detrimental kind of thing in terms of whom Congress wished to welcome into the country and whom it did not. So I don't see the miscarriage of justice particularly.
I want to thank the court for its time. I see my time is up.
You go ahead. It's my custom to let people have the last word, so please go ahead.
Your Honor, I appreciate that very much. I do not want to take any more of the court's time. I have been able to present our case, and I thank you so much for that.
We thank you. We will adjourn court, and we'll take a 5-minute recess and have the courtroom cleared, and then the three of us will reassemble in conference.
This honorable court stands adjourned until tomorrow morning. God save the United States and the